Well, good afternoon, financial professionals. My name is Brendan Derone, Chief Distribution Officer here and Managing Partner at E4 Insurance Services. Welcome you to the Brew, building relationships every week. Thanks for tuning in today. For those of you joining the Brew for the first time, welcome. We like to start the Brewcast off by celebrating today's National Day. Well, first off, it's Administrative Professional Day. So if you have someone special in your office, you may want to give them thanks. And with that, Megan, Danielle, thank you for all that you do. I wouldn't want to have skipped this next one, National Skipping Day, and forgot about you. So National Skipping Day, well, don't skip the brew. You're here. It's good. I'm glad that you're here. And National Scream Day. There's a lot of things I could do with that, none of which I'm going to do on a recorded brew. So when you're outside later, have a scream for fun. Today's brew is wrapping up our April focus planning series on estate planning with Attorney Eric Christoffersen. He's going to share his expertise. Eric's mission is to help families of all backgrounds persevere and protect their financial legacy. He works with estates of all sizes and takes great pride in educating the middle-class families on estate planning and helping them implement techniques previously only available to the 1%. Eric will discuss the importance of having a game plan for your client's estate and in a game where the rules always change. So with that, I'm going to start some rapid fire questions and enjoy the ride. Eric, why don't you just tell us a little bit about yourself to kick things off?
Yeah, awesome. Thanks for having me again, Brendan. Always appreciate collaborating with you guys. I am the managing partner and producing attorney with Grams and Christoffersen Law Firm. We're a estate specialty law firm with 4 attorneys located in the greater Madison area. So one thing we're known for in Dane County is we service the entirety of the Dane County area and actually have 5 offices just in Dane County. And so we really outreach our attorneys into the local communities to make sure that we're interfacing directly with the clients in their local communities. So that's kind of our niche as far as our practice. But of course, one of the things that we always like to do too is support financial advisors. It's something that I've done my entire career with, being involved with NAFA or FPA or other trade organizations specifically for the financial industry, because one thing we believe strongly at our firm is in collaboration with advisors and never being the guy to come into the room and try to one up the advisor, but rather working behind the scenes to collaborate and put on a unified approach for the client, because we believe that's going to be the best outcomes for everyone. So always enjoy doing these kind of educational seminars and just kind of shedding a light into what we do on a daily basis, because we know that you guys are the boots on the ground that really, quite frankly, interface with clients and hear about their goals more frequently than we do. So I think it's always important to get the information in front of you so that you can be best prepared to advise your clients. So yeah, I think that's about what I want to share.
Well, thank you, Eric. It's often said, estate planning is an ever-shifting landscape. What is meant by the ever-shifting landscape?
Yeah, so where I was going with that basically is, the analogy that I always use is we're playing a game. It's a good sports metaphor, but basically you're playing a game, except for the rules of the game are changing, and not just from game to game, they're changing in the middle of the game while you're currently playing. So, I mean, in any other analogy, you'd be like, yeah, that's unreasonable, that's unfair. How can you possibly be expected to play? But that's the landscape that we as advisors are having to advise our clients in, because largely the government is changing the rules at their pleasure to say, hey, this is how we think we're going to get revenue now. This is what we're going to do now. Oh, we passed this law, but what we really meant by that law was this. So we're going to pass some regulations to change what we said in the law. So it's a climate that obviously as advisors, you're being asked to do something that is incredibly difficult to, in a sense, set up a plan, but that plan needs to always be flexible for the rules of the plan actually changing. So that's always is happening, but happening now more than ever.
Okay. And, in regards to the ever-changing landscape, having too much money and the estate tax, what's the game plan there?
Yeah, so that's one of the big changes that we're just preparing for now. And that is that as of the end of 2025, the current very favorable for taxpayers estate tax regime that we've currently been under is set to come to an end. So just to give a little background on that for people who aren't fully familiar with what I'm saying with that, previously under Obama, the modern estate tax was 5 million indexed for inflation. And that was where things sat when Trump first came into office. And so part of the Trump tax reform was actually to double the estate tax exemption from 5 index for inflation to 10 index for inflation. So more or less, we've been under this heyday for taxpayers of many of the clients we work with, at least in the Madison-Dane County market, essentially not having to worry about estate taxes because the exemption went so insanely high. Well, the point is that's coming to an end as of the end of 2025. And when I say that's coming to an end, the law is set to automatically sunset, meaning if no additional laws are passed, we're back down to those Obama levels of the 5 million indexed for inflation. So, which will end up around 6.5. But the point is, a couple things. Number one, to respond to that shifting landscape, people who have been looking at doing any gifting. So this is in particular closely held business owners who might have a lot of their wealth tied up in a business should be looking at by the end of next year. Is there any way I can move some shares at a discounted rate outside of my estate with some gifting strategies, with valuation discounts and irrevocable trusts? Again, some of the strategies are probably beyond the scope of what we can discuss on the call here. But the idea is if you're at a historically high exemption, which is suddenly being taken back down, we've never seen that happen where we've seen exemptions go up, but we've never seen it chopped in half like this. So the one thing is, okay, take advantage of that high exemption now by gifting assets out of your estate. So that's one thing.
And you think that would be grandfathered if somebody and let's assume, and I assume that I guess the way you're talking, you think there's very little chance that something will change and the sunset will happen, the exemption will go down. Is that correct?
That's where we're thinking. Now, again, if you asked us this, a year or two ago, we'd say, yeah, for sure, there's nothing that could possibly happen. But, what you'd have to have happen is basically a massive red wave in which the Republicans retake the House, the Senate, and the presidency, which is what they had under the first 2 years of Trump's term. Then you could see this not coming to fruition. You could see it being extended and basically not sunsetting because new legislation would be passed under those conditions. But that's really, quite frankly, the only conditions under which new legislation could be passed, because if you don't see, Republican majorities in all of those areas, you're not going to see any action taken on this. And then it's going to be automatically sunsetting. So we want to plan for the assumption that, yeah, that's because it's automatic and because that's what's already programmed into the law, that's what's going to happen. Because even if we do see a Republican majority in those areas, the question is that the thing they're going to tackle as their key policy in their first year in office, because that's what they would need to do to have this happen before the sunset in 2025. And we know that this is an area that sometimes is not paid well attention to in Congress. The most recent memory was, it's crazy, it's 14 years ago now, but in 2010, estate tax went away altogether because Congress failed to renew an act and it basically just lapsed for an entire year. So they let it go for an entire year with no estate tax. So if they're willing to do that, I could easily see them willing to, just put it on the back burner and let it sunset back down to, that 5 million index for inflation level.
And you think if somebody does a gift under this historically high gifting, that there won't be any clawback of that? It'll be grandfathered and all will be good?
Yeah, that's correct. That's what we're actually seeing as far as regulations and guidance on that. Again, Could that legislatively change? Yes, but there's not legislation on that one way or the other. So that would fall under the realm of IRS regulations. And what we've seen so far on that is that they would not attempt to initiate clawback. That's fairly certain for the time being.
All right. And so you've discussed those with, higher net worths and, estate tax. How about just protecting the money for, let's call it middle class that aren't in that upper echelon?
Yeah. So the other thing that we're seeing there, and that we're doing actually is, and this comes into portability. So this is again a relatively newer concept within estate tax law. It came during those Obama years as well, and that is that you previously were required to use a credit shelter trust, AB trust, marital trust, family trust. Again, leave it up to the lawyers to have jargon with 3 different names that all mean the same thing. But basically, having that trust created as part of your estate plan to split your estate in 2 at the first death, that used to be the kind of first line of defense against estate taxes to mitigate taxes by utilizing both spouses' exemptions through those trust strategies. Well, now that's no longer required because codified in the law, we have portability, which what that essentially says is that you can transfer a decedent's unused exemption to their surviving spouse by timely filing a federal Form 706 estate tax return. And by doing that, you don't need an AB trust anymore. You can rely on that portability. And largely that's in particular for clients that are in that area of they may or may not have a taxable estate, depending on where things fall. So for example, if you're dealing with a client with, $3-4 million estate, we may very well still be advising that client to elect portability on the basis of, hey, if your exemption is, 6 million and your estate could outpace the growth of that $6 million exemption, I want to make sure that you have 6 plus 6, that you have a $12 million exemption, because then we know that even if legislation changes in the future and further knocks that exemption down, you've got 2 exemptions. And so you're in a very safe spot where you can basically maximize growth on your estate, keep it all in your estate for a full step up in basis on all assets. And so even in that 3-4 million-ish range, we're still advising clients to do portability just to make sure they do get that double exemption. So that's I'd say the huge first line of defense we're doing. And then we are dismantling some of these credit shelter trusts, quite frankly, because if you don't need it, having assets in a separate irrevocable trust is causing additional accounting requirements and hassle to the surviving spouse, as well as that separate irrevocable credit shelter trust will not receive a step up in basis on the death of the surviving spouse. So sometimes strategically we're saying, hey, let's get the spouse together, let's get the kids together, let's agree to get rid of that credit shelter trust, take those assets back into surviving spouse's estate, and then let's claim that full step up in basis. So it's still about, rather than worrying about pushing assets out of the estate to get them out for estate taxes, if we get our exemption at a comfortable level, we can keep everything in the estate and get the full step up in basis.
You said bringing the kids into that conversation. Does that usually go well, or does that take a fair amount of convincing?
I'd say overall it usually goes well, because if the kids understand what you're doing actually is for the benefit of the children, meaning that they're going to inherit those assets with a more favorable tax basis. And so obviously this will depend on the structure of the current credit shelter trust, but at least at our firm, the way we typically structure those is that the spouse is the only one who has the right to draw income from it. If children have rights to draw income from the trust, it may be more difficult to convince them to terminate that trust and give the money back to their parent, because they'd be giving up those immediate income rights. But by and large, it's typically not a problem, and it's more a matter of just explaining, hey, this strategy was good at the time you did it. It was prudent and smart then. But again, the landscape has shifted now, and there's better prudent strategies that we can do now that actually will save you substantial tax dollars by getting rid of this complexity that we previously thought we needed, bring it back in and make it more simple and get that, get that full step up in basis on all the assets.
Sounds good. What are you doing in the case of ILITs and other irrevocable trust planning?
Yeah, so presently, again, because of the historic high exemptions, I'd say ILITs are at a low, meaning they're not being implemented as frequently. But again, this is where I would say practitioners, specifically in the life insurance realm, should be looking to advising their clients at the tail end of 2025. So basically next year, and saying, hey, are you aware you're about to lose your exemption, and you're about to again be in a threat for estate liquidity. Again, this would be more particular for upper clients in terms of higher net worth or business owners or landowners, where again, anyone who could be at risk to, again, we don't presume that you have a double exemption. We always presume that you have one exemption. So if your client has an overall net worth approaching that $5-6 million range, they're going to be at risk starting in 2025. So that's going to be a huge opportunity for the same conversations that we were having a ton of historically in the earlier 2000s about estate liquidity, about having funds to pay for estate taxes, about if you do have those life insurance benefits in place, moving them into an irrevocable trust outside the estate, so that we all know that life insurance benefits are always income tax free. They're not estate tax free unless they're held outside the state in a separate irrevocable trust. So that's something that I think you're going to see a lot more conversation of, because again, it's just going to widely affect a lot more people. Whereas right now, if you're under a $12 million exemption, that's a huge difference than if you're under a $6 million exemption. So once that falls back down, it's a huge opportunity to have that conversation again about life insurance, estate equalization, estate liquidity, having money to pay estate taxes so that you're not liquidating assets such as family businesses or real estate. So yeah, my belief is that we're currently in a valley, but we're about to see a peak on that as far as ILITs go, if things again proceed as we expect them to do with the sunset in 2025.
And are you advising clients that, I guess, don't need to take advantage of the gifting now, wait and see until after 2025, or still move ahead today?
As it pertains to if you're actually gifting shares of your business, we would be advising you to do that. Go ahead and move ahead. If you're looking at putting life insurance in place, because that's probably being funded through annual exclusion gifts through Crummies, that probably doesn't matter whether you're doing it now or today, or excuse me, there's not incentive to do that while you have the higher lifetime exemption. The higher lifetime exemption is just if you're actually going to be doing a large lump sum gift, your window for that very well could be closing. But I do think, to your point, Brendan, as far as wait and see versus do it right now, again, we would advise to do it right now as if you're going to need to do it. But let's say, for example, Joe Biden wins in November. Well, then that's a huge surefire sign to all of those practitioners that 2025 is going to be a huge estate tax planning year, because that the sunset is going to happen. They're certainly not going to extend and renew that under a Biden administration. So if you see Biden get elected, there's, in my opinion, really no hope for reform in that area, and that it's going to be what it is. Versus if you see Trump, then, you might have a little more opportunity to wait and see and say, hey, let's wait and see if Trump takes some immediate action on renewing this. But again, they'd have to still be pretty swift with that, because if he's swearing in January and the law is expiring in December, again, is that your first year is that in your first year of action, and is it early enough that we can actually know what's happening and rely on it and rely on planning for it? We're getting down to a pretty narrow window.
Yep, understand. Finally, let's talk about some income tax changes, both step up in basis, potential of that maybe being repealed, or I don't know if repealed or changed,
Yeah.
and inherited IRA.
Yeah, perfect, perfect. So in terms of step up in basis, that's kind of what I was introducing a little bit earlier when I said, hey, the estate taxes versus the step up in basis, the way our law currently is it's really a tug and pull where it says, hey, if you want to save on estate taxes, then you lose on not getting the step up in basis. But if you keep those assets in your estate, then you're rewarded by getting the step up in basis. Well, as you said, Brendan, that's always on the tax reform, wish list for every Democrat. So again, if you see a blue wave where you get Biden and you have Democrats in control of House and Senate, then that's when you have to start being worrying about, hey, are they going to actually start taking away step up in basis? I'd say historically that's always threatened, but we're not, we haven't seen a serious challenge to that. So we're still operating again as if step up in basis is there and that we can rely on it. And that, again, the trade-off is we're keeping assets in the estate. So we expect that we're going to receive a step up in basis by doing that. So that's, I'd say, what we're seeing on that side. As far as inherited IRAs, the big changes, and this is a different unrelated law to the other tax reform we've been talking about, and this is the Secure Act, which was passed largely with bipartisan support as this great reformation of retirement benefits for seniors. And in reality, it did close the door on some nice estate planning options relative to stretch IRAs. So we were previously able to stretch IRAs over the full life expectancy of the beneficiary, meaning, we had plans out there where grandparents would leave their IRAs in a trust to their grandchildren, and those grandchildren, could potentially have upwards of a 70, 80-year life expectancy, and we could stretch the IRAs that many years. Well, the Secure Act closed the door on that and basically said, hey, you have to take that IRA over 10 years, and the inheritor has to completely liquidate that out of the IRA over that 10-year term. And this is, again, where you talk about shifting landscapes. So they passed this law that says you've got to do it over 10 years. But part of that initial law said nothing about when do you got to take this over the 10 years. And so we were telling clients, you just got to take it at any time over those 10 years. So don't take anything, don't take anything those first 5 years, 6, 7 years, even depending on how large of an IRA you're dealing with. And then, 7, 8, 9, take those in the final years, because again, you're enjoying complete tax deferral until the final years when you have to take it out. And then just make sure you're not taking out too much in any given year that's pushing you into too high of brackets. But that was the strategy based on the Secure Act. And okay, how are we going to maximize under this new rule? Well, then they did, the 2.0 clarification on this and said, oh, by the way, what we meant was you actually do have to take even required minimum distributions over that 10-year term. And so then it's like, oh, thanks again for changing the rules on us. And so now IRA options are much more limited, because inherited IRAs, you're just going to be limited to that 10-year fixed term with even required minimum distributions throughout the 10 years, which again is still highly beneficial to get an additional 10 years of tax deferral out of that IRA, but it has to be spread evenly now with standard required minimum distributions. So there's not really any creative planning you can do other than, again, still encouraging clients take advantage of the 10-year stretch. That's still a good thing, even though it's worse than what was prior and then way worse than what was prior to that. So we're definitely seeing a trend on cracking down on that inherited IRAs, inherited IRA bit. So that's something to be aware of. And again, potentially, if there's, as it pertains to estate planning, if the client has charitable inclinations, it makes the charitable strategies more favorable, because if your strategies to leave to real person, children, grandchildren, beneficiaries, if you're closing out opportunities there, it means that the opportunities for charitable donations, maybe comparatively look more attractive. So I think we'll see, potentially more charitable trusts with IRAs, or just straight leaving IRAs to charity as beneficiary, because, charities, of course, can enjoy 100 cents on the dollar, as well as if you do it through a charitable trust strategy, the client can enjoy an upfront immediate income tax deduction. So we always do this if a client sells a business again, you can set up some a charitable trust and do some contributions to charity with that, with some of the sale proceeds to offset the income on that, as well as, we will sometimes do, if we have a charitable trust that's generating a big deduction, can do a Roth conversion still to generate some income, which is offset by that charitable deduction. So there's some great strategies here in this area. And then again, particularly as it pertains to life insurance practitioners, there's an opportunity to say, hey, that money that you would have left to your kids that you decided to leave to charity instead, let's do replacement on that, what's sometimes called a wealth replacement strategy. Let's take the annuities that this charitable trust is paying you, and let's roll those in instead of just paying them back to you since you don't need them. Let's take those and roll them in and make those be premiums on a second to die life insurance policy, and have that life insurance payable to your kids to essentially replace the money that would have gone to them. You basically get to have a charitable legacy tax-free. You get to have the family legacy tax-free through the life insurance. And it's a very nice strategy that I think, again, maybe more opportunities to do this type of strategy, not because it's more favorable to do charitable planning now, but just because it's less favorable to leave those IRAs to family members now.
And the only one who loses in that equation is the government, which
yeah.
I don't think anybody's going to lose sleep over.
No, whenever you can do a strategy that leverages multiple tax-free benefits in the tax code, that's always a great strategy for the client.
So putting a bow on your sports analogy, and maybe giving you a curveball to throw in another sports analogy, is it better to have a good offense or a good defense?
Yeah, good question. They always say the best offense, or what is it? Is it the best defense is a good offense? Either way, you gotta look at it from both, I would say. In terms of when I'd say going on the offense is when you proactively start gifting assets. You set up a trust. You're doing proactive strategies. I would consider those going on the offensive, where you're actually taking proactive action to mitigate estate taxes. Defense, I would kind of consider as the basics. Do you have the basic defensive posture to protect yourself as you would need to with, your estate size relative to the exemption, with portability, with moving insurance into an ILA, some of those things that's just like defensively protecting versus getting aggressive. So I guess I would say they're both important, but I would always take the defensive posture first. Make sure that your estate is protected, and that you're defending against what you have. And then once you have the defense, built up, then you can start saying, hey, what are some things where I can actually go on the offensive and take further advantage of strategies that are out there? So I would say both important, but defense first.
Wonderful. Appreciate it. And thank you for sharing your wisdom with us. Obviously, Eric's very passionate about what he does. If you are in the greater Dane County area and would like to see him, you can reach out and we can get you his contact information if you can't find him on the web, but he's pretty accessible. We will open it up if anybody has questions from the audience. Now is your time to ask. Either unmute yourself or pop it in the chat box. Well, we wait to see if there's any questions. As a reminder, we do have a giveaway. Eric, could you pick a number between 1 and 25?
13. We'll make it turn. We're going to turn the unlucky into the lucky.
All right. Greg Imhoff, number 13 is our winner. So congratulations, Greg. Always great to have you on. I know you are a regular, so you do win. All right. On next week's brew, we kick off a new month of our focus planning series. And with May being Disability Awareness Month, it is going to be disability. Myself and Brady will be hosting our initial brew in May. We'll discuss why E4 is here for your DI needs, our successes, and what's on the horizon. With that, thank you again, Eric. Really do appreciate it. It's always a pleasure to have you. Thank you for everybody being in attendance. Have a great rest of your Wednesday, and we'll see you on the next brew.